Now, let's review exemptions to property. In a later lesson, we'll learn how a person may be fully or partially exempt from property taxes. At the end of this lesson, you will be able to identify whether the listed properties are taxable or exempt. Real and personal property owned by a governmental entity and used for public purpose is exempt from local property taxes. If the property is not owned by the entity, it is not exempt. Property owned by the United States is exempt under the United States Constitution unless Congress expressly permits it. This exemption is found in Clause 1 of General Laws, Chapter 59, Section 5. The exemption also applies to property held by federal instrumentalities, for example, the American Red Cross and the Federal Deposit Insurance Corporation, or FDIC. In addition, under treaties to which the United States is a signatory, property owned by foreign governments, such as embassies, consulates, or vehicles, or by individuals working for those governments, is usually exempt. Under the Supremacy Clause of the Constitution, these treaty exemptions apply to taxes imposed by states and their political subdivisions as well. Property of the Commonwealth is exempt under Clause 2. There is no clause or other statute that exempts property owned by cities, towns, districts, and counties. However, court cases have held that property of these political subdivisions used for public purposes is exempt wherever it is located. Property of independent authorities and other public instrumentalities is also usually exempt under their enabling acts. This would include, for example, property owned by housing, redevelopment, transportation, port, and other authorities, and held for the purpose for which the authority was established. Note, however, that real property of the United States, the Commonwealth, or a county, city, town, or any instrumentality may be taxable if it is leased, occupied or used for business, or non-public purposes as covered in General Laws Chapter 59, Sections 2B and 3E. In that case, the lessee, occupant, or user is treated as if it owned the premises it rents or occupies as of January 1st and is taxed or exempted as if it were the actual owner. One of the most commonly granted exemptions is for real and personal property of charitable organizations under Clause 3 of General Laws, Chapter 59, Section 5. Clause 3 establishes certain tests for property to qualify for a charitable exemption. First, the owner must be a charitable organization that occupies the property for its charitable mission. Alternatively, the property can be occupied by another charity for its charitable mission or have been acquired by the organization with the intention to relocate there. The organization must devote its resources to charitable activities. So the second test is that its income or profits cannot be divided among stockholders, trustees, or members. And the third is that its assets must be turned over to another charity if the organization is dissolved. The fourth test is that the organization must follow all procedural requirements for the exemption, including an initial application for exemption and an annual property return. The owner of the property must be a charitable organization. Clause 3 defines a charitable organization for property tax exemption purposes as a corporation or trust, established or formed for literary, benevolent, charitable, or temperance purposes. An entity that is a limited liability company, or LLC, or has another organizational structure is not eligible. Being a nonprofit organization is not sufficient, nor is exemption for state or federal tax purposes. A corporation or trust must be organized or created for charitable purposes and must actually operate as a public charity in order to qualify as a charitable organization for property tax exemption purposes. To operate as a public charity means the actual work done by the organization must be consistent with its stated charitable purposes. The work must benefit a sufficiently large or indefinite class such that society at large benefits, not just a limited group of people. There is no precise number of persons who must be served, and at any given moment, it may be a smaller number. However, those in the class served should be fluid and drawn from a large segment of society or all walks of life. If the dominant purpose in work is for the benefit of the organization's members, it is not a public charity, even if its work provides some incidental benefit to the public. The dominant purpose in work of the organization must be for the public good. Providing commendable, laudable, and socially useful services is not sufficient. As indicated earlier, the organization's income and assets must be exclusively for charitable purposes. No private inurement is permitted. That is, the organization cannot further or advantage the private interests of those who run and operate the organization. The organization must be organized for charitable purposes. In a number of cases, the courts have defined charitable purposes to include a wide field of activities that further the improvement of humans and lessen the burdens of government. They include providing education and medical care, promoting the arts, assisting those in need with the necessities of life, and maintaining public spaces. The benefits do not have to be provided to just low-income or other persons in need. An auxiliary organization whose purpose is to raise funds for a related charitable organization, or to reduce the overall cost of operation of a related charitable organization by performing a necessary function for it, may also qualify as a public charity for exemption purposes. An organization incorporated or created by trust in another state can qualify for a charitable exemption on property owned in Massachusetts. This is so even though Clause 3 states the exemption applies to charitable organizations incorporated or charitable trust formed in Massachusetts. In the case of Mary C. Wheeler School, Incorporated versus Board of Assessors of Seekonk, the Supreme Judicial Court held that the Equal Protection Clause of the 14th Amendment of the U.S. Constitution required that a foreign corporation or trust, if otherwise qualified under Massachusetts law, be eligible to receive a Clause 3 charitable exemption. The Mary C. Wheeler School, Incorporated, was located in Providence, Rhode Island, but had purchased land in Seekonk for athletic fields. As a general rule, a private nonprofit educational institution's athletic fields would be exempt. The court held that the exemption should not turn on the state of incorporation. Once the Commonwealth permitted an out-of-state entity to operate in Massachusetts, the Massachusetts property tax laws must apply as equally to it as to a domestic, that is, Massachusetts corporation. Therefore, an out-of-state corporation or foreign charitable trust may qualify for a charitable exemption, but it must be registered with the Secretary of the Commonwealth to do business within Massachusetts. Examples of charitable organizations that qualify for exemption of their real and personal property include nonprofit private schools, colleges, universities, hospitals, museums, and recreational facilities. They are organized for charitable purposes, and their work and activities benefit a fluid, indefinite class of the public. A property is not eligible for exemption if the nonprofit entity does not meet the tests for a charitable organization. That is, the entity does not benefit an indefinite class of the public. Here are some examples of nonprofit organizations that have been found to be ineligible for a charitable exemption for that reason. A nonprofit chamber of commerce is taxable because it operates primarily for the benefit of business members and only incidentally for the general public. It is formed to foster and promote good business and commerce in the community, and its activities are primarily directed for those goals. A nonprofit insurance library is exempt from federal tax and conducts seminars and courses of instruction on various types of insurance. There is free on-site use of the library, but it has a strong business orientation and functions primarily for business purposes. Members primarily consist of insurance companies, insurance agents, and brokers, attorneys, consultants, and others directly involved with the insurance business. Membership is not open to the public, but requires approval of the membership committee. A nonprofit yacht club is a social or recreational organization formed primarily for the benefit of the members. The fact that it incidentally does good works for the benefit of the general public, such as awarding scholarships to students in the community, does not make it a public charity. Again, it is not enough for the entity to be a nonprofit corporation or exempt from federal or state taxes. A property is also not eligible for exemption if the nonprofit entity does not meet the income test for a charitable organization. That is, the entity's income is not used for charitable purposes, but is distributed among stockholders, trustees, or members. Here is an example of a nonprofit organization that was found to be ineligible for a charitable organization for that reason. A private school was denied the charitable exemption because of the compensation paid to 5 members of one family who appeared on the school's payroll. While their presence on the payroll would not automatically defeat the exemption, in this particular case, the Supreme Judicial Court concluded that the salaries were not reasonable and not paid for services rendered. Instead, the court determined that the payments were a cloak to conceal the distribution of profits. If the nonprofit entity that owns the property is a charitable organization, all of its personal property is exempt. However, its real property must be occupied by the owner or its officers for its charitable purposes, or another charity or its officers for its charitable purposes. Occupancy means using the property in ways or for the activities that directly accomplish the organization's charitable purposes and that directly benefit the public. If all or part of the property is occupied for non-charitable purposes, it is not exempt. Here are some examples of nonprofit organizations that have been found to be ineligible for a full or partial charitable exemption for that reason. A nonprofit hospital is not exempt on portions of the hospital rented or made available to doctors for their private practices of medicine. Although a charitable organization owns the space, the doctors occupy and use it for their private practice. A nonprofit hospital owns a garage, which is used by visitors to the hospital and the nearby medical office building. The garage was partially exempt based on the portion of the garage reserved for hospital patients and visitors to the hospital. The portion of the garage used by the visitors to the medical office building is taxable. A nonprofit corporation operates a commercial printing business in its building. Money derived from the business venture is used to provide aid for certain individuals, which is the purpose of the organization. The real estate is taxable, however, because the dominant purpose for which it is used and occupied is a commercial printing business. That activity is not related to the charitable purposes, but is commercial in nature. A frequent issue is whether housing owned by a nonprofit organization is occupied by the organization for its charitable purposes. In this example, a group home for disabled persons is owned by a nonprofit corporation and operated by it or by another nonprofit corporation under a contract with the Commonwealth. This housing is exempt. The entities are organized to provide services to disabled persons, a charitable purpose, and they provide on-site supervision and care of the persons living in the home. The residents have a limited possessory interest in the premises and have little expectation of privacy. Occupancy is in the nonprofit entity, which is using it to accomplish its charitable purposes. In contrast, a nonprofit corporation organized to construct and provide affordable housing is taxable for an apartment building it owns and rents to low-income persons for below-market rents. Although the organization owns and operates the building consistent with its charitable purposes, the tenants are the occupants of their units. As lessees, they have the possessory interest in their units, that is, the exclusive use and occupancy of their units under their rental agreements with the expectation of privacy. Note that while the corporation is constructing affordable housing, it would be occupying the property for its charitable purposes and would be exempt. The exemption ends once it rents or sells the housing. Housing owned by a nonprofit educational institution and used by faculty or other employees is occupied by the organization's officers and exempt if certain tests are met. First, the faculty housing is a means of adjusting the employee's compensation so that rent, if any, is minimal and not intended to produce income for the institution. Second, residency in the housing must be a condition of the faculty members' or employees' employment. Third, The occupancy advances are as essential to the mission of the educational institution. Finally, the housing must be part of or contiguous to the principal location of the institution. A nonprofit corporation owns and operates an assisted living facility for older persons. If the entity limits the pool of eligible residents because of its monthly and other fees or deposits charged or other conditions, it may not operate as a public charity because it does not benefit an indefinite class of the public. Even if it qualifies as a charity, however, the residents of independent and assisted living units would generally be the occupants of their units. Note that if the facility has a licensed nursing home or rehabilitation and skilled care unit, that portion may be exempt if it accepts patients from all walks of life, including Medicaid patients. If a charitable organization acquires property, it has 2 years from the acquisition to construct a facility or renovate the property and occupy it. The organization must have acquired the property with the intention to relocate all or a substantial portion of its operation there, and must continue to have that intent to relocate during the next 2 years. During the 2-year period, the organization is considered to be occupying the property. If the organization does not actually occupy and use the property for charitable purposes by the end of that period, however, it is taxable until the property is actually occupied. A charitable organization is not automatically exempt from local property taxes. It must apply for exemption in the first year it seeks to exempt its real or personal property in the city or town, and after that in any year it seeks to exempt a parcel of real property not previously exempted. Applications are due the same day as abatement applications, that is, the due date of the first installment payment of the actual tax bill for the fiscal year. The organization must provide you with all requested supporting information that is reasonably required to establish it as a charitable organization. This information may include, but is not limited to, its articles of incorporation, charter or declaration of trust, its bylaws, the identity of officers, directors, or trustees, a description of its charitable activities, and a description of the use of the property, including use by all lessees or other occupants. Once an exemption is established for that property, the organization does not have to reapply unless there is a change in ownership, occupancy, or other eligibility criteria. Charitable organizations must file an annual property return in order to receive an exemption under Clause 3. The return is required if the organization owns property in your city or town on January 1st, and it claims exemption for that property for the fiscal year beginning on the next July 1st. The return, known as the Form 3 ABC, is due March 1st. You may extend that deadline if the organization applies in writing and provides a good reason for it. You can extend the deadline to any date up to the abatement application deadline for the fiscal year. However, if the organization does not file a return for a fiscal year, you cannot exempt it for the year. Charitable organizations must register with and report annually to the Public Charities Division of the Attorney General's Office. They must include a copy of their most recent report, the Form PC, with the Form 3 ABC filed with the assessors. Except for the property schedules contained in the return and Form PC are subject to public disclosure. Note that veteran organizations seeking exemption of real or personal property must also file this return. A fraternal organization is an association of persons formed for mutual aid and benefit, not profit. The members typically have a similar calling, avocation, or profession, or are working together to accomplish some objective, or have banded together to aid and assist one another and to promote a common cause. It operates under a lodge system, or the exclusive benefit of its members and their families, and typically pays death, accident, sickness, or old age benefits from dues paid or assessments made on members. All personal property owned by the fraternal organization is exempt from local property taxes under Clause 7. However, There is no specific exemption for the real property of a fraternal organization. The organization's real property is exempt only if the organization also qualifies as a charitable organization and the property is occupied for charitable purposes. In other words, it is exempt only if the organization meets all substantive qualifications and procedural requirements of Clause 3. If the fraternal organization also qualifies as a charitable organization, it can receive an exemption. However, the exemption is limited to that portion of its real estate occupied for charitable purposes. In Knights of Columbus versus Assessors of Worcester, for example, the Supreme Judicial Court determined that 10% of a building the Knights of Columbus owned was apportioned for charitable purposes. Specifically, it found the library, reading room, and hall were used for the charitable purposes of the organization, and the organization was eligible for a partial exemption on that space. Real and personal property owned by or held in trust for an incorporated veterans organization like the Veterans of Foreign Wars, or VFW, is exempt. The exemption is found in Clause 5, or local acceptance clauses 5A, 5B, and 5C. Each clause exempts up to a specific dollar amount of the value of the organization's real estate and personal property. Under Clause 5, each qualifying veterans organization receives an exemption of up to $200,000 of the value of its real and personal property. If the city or town accepts one of the local option clauses, the amount of the exempted value is set at a higher amount, as shown here. To qualify for the exemption in effect in the city or town, the veterans organization must actually occupy and use the property and must devote its net income from its property for charitable purposes. In addition, it must file an annual return of property held for charitable purposes, Form 3ABC, if it owns property in your city or town on January 1st and claims exemption for that property for the fiscal year beginning on the next July 1st. The return is due the same day as returns from charitable organizations, that is, March 1st, or the date of any extension you grant. Unlike charitable organizations, however, a veterans organization does not have to attach a Form PC, since it is not required to submit an annual report to the Public Charities Division of the Attorney General. Clauses 10 and 11 provide exemptions for property of a religious organization of any denomination. Clause 10 exempts all personal property owned or held in trust for use by a religious organization for religious or charitable purposes. Clause 11 exempts the following real property owned or held in trust for a religious organization: a church, synagogue, mosque, or other house of worship used and occupied for religious services or instruction, and a parsonage used and occupied as a residence for its clergy. A house of worship is not just the structure and rooms used for services and religious instruction, but includes parking lots, church halls, offices for clergy and staff, and other areas used for purposes that are connected with religious worship and instruction, and accompany and supplement the religious work of the organization. A parsonage is a residence occupied by the religious leader, pastor, or other clergy person of the denomination, who regularly officiates or conducts services at the congregation's house of religious worship. It does not include housing occupied by other officials or employees of the religious organization. Vacant land or a building acquired or held by a religious organization for place to worship is taxable. Construction or renovation has to have begun for property to be considered a house of worship and the exemption to apply. Incidental or occasional use for other purposes by an organization exempt for federal taxes under Section 501c3 of the Internal Revenue Code, such that it does not interfere with the religious use of the property, does not make the property taxable. However, if the dominant purpose in occupancy of any portion of the property is for purposes other than religious worship or instruction, that portion is taxable. All other property of a religious organization is taxable unless it qualifies under another exemption. Since most religious organizations are also organized for educational and other charitable purposes, their real property may qualify for exemption under Clause 3. This would include, for example, their schools, hospitals, and social service and other facilities. For those properties to be exempt, the religious organization has to meet all qualifications for a Clause 3 exemption. In addition, they must follow all procedures for a Clause 3 charitable exemption. This includes filing an annual return, Form 3 ABC, but a religious organization does not have to attach a Form PC since it is not required to submit an annual report to the Public Charities Division of the Attorney General. A religious organization does not have to file an annual return for its property exempt under Clauses 10 and 11. That is its personal property, house of worship, and parsonage. The Commonwealth reimburses cities and towns for loss of tax revenue on some property it owns, depending on the agency holding it and its use. It does not reimburse cities and towns for other exemptions granted to privately owned property. This lesson started with the premise that all real and personal property is taxable unless otherwise exempt. It then provided an overview of the exemptions available for governmental entities and certain types of organizations. Please review the key takeaways, then click the next arrow button to check your knowledge.